Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today has been a really interesting day for crypto, specifically for XRP, as the price moved from about $1.30 to about $1.20, and right now we are exactly in the almost exactly in the middle at about $1.24. And well, I have a question for you all right? This is a question which I think a lot of you guys are gonna benefit from, and the question is, guys, if you could pick 3 cryptos out of the top 25, which 3 would you pick? The reason I'm saying 25 and not longer is because very often people show these really small, really sketchy projects. I don't want to see any of that. All right, this project that you are talking about here must have some significant market cap and significant percentage in the crypto space. Not exactly sure what to call it right there. Some specifically high influence, basically. But it might benefit others because I have said on the channel before, it is really important to diversify. And even though you can definitely find my entire portfolio over on Patreon, a lot of people still wonder what type of coins I hold, just the people watching these videos, and I do some updates left, right, but not really as clearly explaining all the coins. And point being, guys, sometimes it's smart to take somebody else's advice for it in the comment section, even though they're random people. Very often these guys have some really thought out ideas, and think about it, guys. If you're watching this video right now and you do a ton of research on crypto, there's most likely a ton of other people in the comment section too who do exactly the same thing. So make sure you press that like button to this video. And by the way, guys, I just keep on buying more. Even right now, I'm thinking, you know what? What if you just break out to at the top of the channel? I'm still expecting XRP to hit this $1.34 for a second, or basically double top at least, all right? Luckily, I guess I bought yesterday in at around this area, my 250 XRP, but still, I guess I should have just bought more, right? That's that hindsight little feeling. But that's all besides the point for right now, guys. Bybit is the platform I trade on. If you guys want to check it out, a link is down below, but let's move on. First of all, America's second largest mortgage lender will be accepting Bitcoin payments later this year. Not specifically anything tying it towards XRP, but as you guys know, I like to cover crypto news that matters. So it's not always going to be XRP. It's stuff that you need to know about if you are a crypto holder. And this is exactly that, all right? And one thing about the snowball effect, which we sometimes talk about in the context of Ripple, sometimes in the general crypto context. In this specific case here, they're even mentioning the entire El Salvador movement, basically. And I do believe, too, that it'll be a really big part. You know, that El Salvador accepting it will be a really big part in the bigger picture. But that's just what I just quickly wanted to let you guys know. All right, I think it's going to be a lot more significant than people are making it out to be. All right, El Salvador itself, the country, don't really matter too much, right? It's just one little small country. It ain't going to do nothing. It's about the idea and the snowball which has now rolled off the hill. All right, John Deaton over on Twitter is definitely a source of information which I cherish, but more specifically here, a lot of people are thanking John Deaton for what he's done, and a good part of it is now because of the SEC investigation into the SEC. It's not actually the SEC investigation, it is the investigation by, I forgot the freaking name for it. Who really cares exactly what party did it? It's the fact that they're getting freaking, dug up that I like. Ooh, wait a minute. Maybe we're seeing something else? Oh, so something just got added actually. Just added to our document library. Defendant's response to the SEC opposition to motion to compel production of internal documents. Read it here. What the SEC does not, because it cannot defend, is its across-the-board assertion of deliberative process privilege, DPP. Instead, it asked the court to trust it, order production of nothing, and look at nothing. Notwithstanding the SEC's admission, buried in a footnote, that it improperly designated 40 documents as protected by DPP when that privilege does not apply. The letter argues the SEC keeps fighting against producing materials that Judge Netburn had already ordered it to produce. and its manic efforts are to shield themselves from the weakness of the case they filed against the defendants. The letter also notes that Hinman's claims about XRP are refuted by the SEC's own arguments opposing John Dean's motion to intervene, and that Hinman's personal views on XRP are dubious. See footnote 2 in this document. But this is pretty nice. All right. Once more, I wasn't actually prepared for this because it just came out about an hour ago. And as I've explained a couple of times before, usually I just wake up, I go look for a couple of news articles, I take them open and put them open. Then a couple of hours later, I go on another session. I just open a couple of articles I like and I think are interesting. I go read through it throughout the day. And at the end of the day, or a couple of hours later, let's say for example an hour or 3 in the afternoon, I start recording a video, for example. And in this specific case here, I just got done recording a video about the law. I now was doing more and more research into some other stuff which I want to talk about. And in this hour of me just sitting around doing some research, apparently some new info came out. So that's sometimes what happens when you're just busy all day looking at this stuff. Yeah, we might be an hour too late, which might be annoying, all right? Sometimes I also do wonder what's wrong with me. Guys, we're talking about an info that came out 1 hour ago, and I'm feeling guilty for being a little bit late. What's going on here, right? But let's also quickly check out the official document if we can. I think James Fillon most likely also posted it, but let's quickly see. So, on behalf of Ripple and Bergolius and whatnot, the SEC's argument that the materials sought are irrelevant or untimely ignores the court's prior rulings. Yes? Because, of course, the court had already ordered them to be given. The SEC ignores that the DPP, deliberative process privilege, which basically just asserts that a lot of the documents which the SEC has should not be given over because, well, they have some government protections. The SEC ignores that the DPP is a qualified privilege and that this is an extraordinary case. Basically just overextending the DPP is what Ripple's saying. The SEC fails to substantiate its assertion that narrow, limited disclosure under a protective order would chill future deliberations. This had to do with the fact that the SEC said, if all this stuff came out right now, it might deter some officials from actually making public statements or for people from becoming officials in the future, which Ripple thinks is kind of stupid. Because if that's the case, what? That just doesn't make any sense. And the SEC's shifting position on the application of privilege counsels in favor of an in-camera review. So this one we want to read a little bit further into. The SEC's opposition to an in-camera review appears to rest on a blanket assertion that because it had appropriately determined that factual material is inextractably intertwined with protected deliberations for every document without exception, and because it had logged the documents it would held, in-camera review is unnecessary. Now, little fun fact, the SEC really shortly ago actually claimed the same thing for Ripple, saying, hey, we actually think that your blanket sealing, it was about a seal, is stupid. We don't really want that. And now Ripple's kind of fighting back about this blanket argument. Now, Ripple's saying that this is no response at all, actually. Defendant's objection is not that the SEC has not logged the documents. Defendant's objections are, one, that it is implausible that the SEC's review of withheld documents has identified not a single one solitary piece of non-deliberative or factual material that can be disclosed among the responsive documents. So they basically are saying nothing is useful. And two, that in any event, in-camera review would reveal that compelling production is appropriate even if the DPP might consider otherwise apply. In light of the factors discussed above, even in the cases cited by the SEC, courts would typically perform an in-camera review of the documents at issue. Right? In fact, there are good reasons here to be concerned that the SEC's blanket invocation of the DPP is inappropriate, thereby making in-camera review particularly appropriate if the court declines to compel their production at this time. For one, although buried in a footnote, the SEC now admits that 40 documents previously withheld on DPP grounds are not, in fact, subject to the privilege. So the SEC first said, no, we don't want to give this information out. We don't have to DPP, right? We don't have to give you this info, even though the judge did order it. And now a little bit later in a footnote, they're saying, you know what, we are giving it over. You know what, we're having a second opinion. You know, we're just giving it over to you, right? We want to, which is sad. Now, the SEC continues to assert either attorney-client privilege or work product protection over all but 11 of these 40 documents. That belated concession confirms the SEC's overbroad assertion of privilege in this case. Had defendants not filed their motion, this overbroad assertion of privilege would not have been identified. So this basically shows once more about the fact that the SEC is most likely misjudging a lot of this stuff, and the fact that the SEC is now invoking other privileges as a means of continuing to withhold more than 70% of these improperly designated documents raises further questions about the propriety of the SEC's invocation of these other privileges, including its improper use of the attorney-client privilege to withhold documents involving SEC staff, who happened to be lawyers, but whose roles were not those of counsel in the commission or its staff. And likewise, the SEC's assertion that its privilege logs are over-inclusive and include supposedly non-responsive communications should give the court pause. Defendants have maintained since the onset of this litigation that to the extent the SEC possesses documents evidencing its own uncertainty or confusion around the regulation of digital assets, it should produce those documents. The stakes are simply too high to operate on less than a full record, particularly when individual liability is at stake. In this regard, defendants gave the SEC clear notice weeks ago that they intended to challenge the SEC's assertion of DPP in this case. It is difficult to conceive why, in that context, the SEC would have logged dozens of putatively non-responsive communications and then produced none. At a minimum, the court should review those documents before accepting the SEC's belated assertion that they are in fact not responsive. And I really firmly, for the first time I think ever, firmly 100,000% agree with Ripple. The SEC has no right to claim that every single document that they have cannot be seen by anybody else besides them, or cannot be used in this lawsuit. That sounds dumb to me. The SEC's opposition makes a number of other points that are addressed in defendant's motion, and defendants refer to and reply to that motion rather than repeating those points here. What a freaking show this is, guys. It really makes my head bonk a couple of times a day. Just thinking about how this is going back and forth and back and forth. It feels like there's no end. Then again, it keeps getting dumber and stupider and stranger. Because right now, literally, what I'm seeing is that the SEC has stated everything that they ever got, all those documents, cannot be used in court. Yet, within that claim, a little bit somewhere in the smaller parts, they're like, yeah, but a couple of things we can give. So, like, what is this? I would say, SEC, if you're going to stick with such an explanation, stick with it to the core. Don't change halfway. And also, if you're going to fight it like a man, fight it like a man. Don't sissy out. Literally, what they did is just, instead of fighting the full battle, they were like, no, we want to take it a little bit easier. We're going to give you a couple to make it easier on ourselves and, because we don't want to fight. What is this, right? I really don't get it at all. Then again, I'm not a lawyer, not a financial advisor, not any advisor for that matter. We're just normal people reading through this stuff as best as we can. And this letter looks really good. That's the only thing I can kind of tell you for right now. We've read every single one of the Ripple v. SEC letters, and this is the one that has actually made me most bullish out of all of them because I cannot, all right, and I don't want to slam my desk right now because it's freaking, check. It's already about 2 a.m. I do not want to slam my desk. I almost kind of have to, though, because I cannot see a scenario in which the judge is going to deny this. If she does, I'm scratching my lip a little bit right here. I'm not sure exactly. I'm going to call out some crazy names at that point, and we're going to have to sit down, all of us, and just kind of chat for a little second, because then something is ridiculously wrong or ridiculously fishy. So, yeah. But guys, that was it for today's video. Hopefully y'all enjoyed it. If you did, make sure you press the like button and subscribe. And I kind of had a difficult video or different video in mind. Turned out to be a lawsuit type of video, I guess. But it's good because it was breaking news. It was rather interesting. And I'll see you guys again in another crypto video later today.